Hey everyone, my name is Mac Nomura and I'm a trainer here at US Realty Training. Today, we're covering 25 questions you will see on your Illinois real estate exam. If you would like more questions like these, US Realty Training provides a state exam prep package in Illinois that comes with practice exams, terminology flashcards, video explanations, and an e-study guide. If you're interested, the link for that is in the description and in the comments below. With that said, let's start with your first question. In Illinois, if a sponsoring broker has one licensee who's representing a seller and another licensee who's representing a buyer for the same property, the sponsoring broker is A, considered to be acting for both parties, B, considered to be an undisclosed dual agent, C, not considered to be acting for more than one party, D, an implied agent. And the answer is C as in Charlie, not considered to be acting for more than one party. A sponsoring broker entering into an agreement with any person for the listing of property may specifically designate those licensees employed by the sponsoring broker who will be acting as legal agents of that person. A sponsoring broker shall not be considered to be acting for more than one party in a transaction if the licensees specifically designated as legal agents of a person are not representing more than one party in a transaction. Charlie, a licensed broker, wants to sell his condominium that he co-owns with his mother. Naturally, he lists the property with himself. One day, a buyer who Charlie represents comes to the office and wants to buy the condominium. What must Charlie do at this point? A, have the buyer sign the dual agency form. B, have his mother sign the dual agency form. C, disclose his ownership interest to the buyer. And D, withdraw from being the buyer's agent. And the answer is D as in dog, withdraw from being the buyer's agent. A licensee shall not serve as dual agent in any transaction to which he or she or an entity in which he or she has an ownership interest, directly or indirectly, is a party to the transaction. According to provisions of the Illinois Residential Real Property Disclosure Act, A, seller must disclose residential property defects to buyers. B, seller must disclose residential and commercial property defects to buyers. C, seller must disclose material property defects to their agents. D, sellers who list with agents must disclose property defects to the IDFPR, the department. And the answer is A as in apple. Sellers must disclose residential property defects to buyers. The Act requires disclosure of material defects to buyers provided that the property in question is a 1 to 4 unit residential property. The disclosure is required whether the property is listed or not. There are, however, several exceptions to the disclosure requirement. In Illinois, if a home seller discloses a material defect of the property to the buyer after completing a binding sale contract, in accordance with the Residential Real Property Disclosure Act, the buyer, A, may rescind the contract if done within 3 business days after receipt of the disclosures. B, may rescind the contract if done within 7 days after receipt of the disclosures. C, has no recourse since the contract was executed. D, must accept the contract terms but may sue the seller after closing. And the answer is A as in apple, may rescind the contract if done within 3 business days after receipt of the disclosures. If a material defect is disclosed in the Residential Real Property Disclosure Report after acceptance by the prospective buyer of an offer or counteroffer made by a seller, or after the execution of an offer made by a prospective buyer that is accepted by the seller for the conveyance of the residential real property, then the prospective buyer may, within 3 business days after receipt of that report by the prospective buyer, terminate the contract or other agreement without any liability. In Illinois, the practice known as dual agency, A, is illegal in commercial real estate transactions. B, is illegal without written consent. C, is permitted with informed consent. D, is permitted with written informed consent. And the answer is D as in dog, is permitted with written informed consent. A licensee may act as dual agent only with the informed written consent of all clients. Joyce, a buyer, walks into a real estate office and meets Lenny, a broker. Lenny shows Joyce a house listed by Angela, another broker in the office. Who is considered to be Lenny's client in this situation? A, Joyce. B, Angela's seller. C, Joyce and Angela's seller. D, it cannot be yet determined. And the answer is A as in apple, Joyce. Licensee shall be considered to be representing the consumer they are working with as a designated agent for the consumer unless there is a written agreement between the sponsoring broker and the consumer providing that there is a different relationship. However, a licensee acting as a designated agent must advise a consumer in writing no later than beginning to work as a designated agent on behalf of the customer that a designated agency relationship exists unless there is another written agreement providing a different agency relationship and the name or names of it is or her designated agent on a written disclosure. A buyer tells listing agent Doug that he and his wife can pay cash for the listed property. Doug happily passes that information along to the seller, who subsequently accepts their offer. It is later discovered that the buyers have very little cash and have to do a VA financing. Furious, the seller threatens to sue Doug for misrepresentation. Is Doug liable? A, yes, since he intentionally misrepresented a material fact. B, yes, since he lied, albeit unintentionally. C, no, since the seller should have known the real facts. And D, no, since he merely passed on what the buyer had told him. And the answer is D as in dog. No, since he merely passed on what the buyers had told him. A licensee shall not be liable to a client for providing false information to the client if the false information was provided to the licensee by a customer unless the licensee knew or should have known the information was false. According to Illinois law, licensees must disclose facts to clients. A, if they are material, known by the agent, and impact the transaction. B, regardless of their impact on the transaction unless the agent had no knowledge of the fact. C, if they are material, regardless of the confidentiality. D, regardless of the impact of the properties, if known and not confidential. And the answer is A as in apple. If they are material known by the agent and impact the transaction. A licensee representing a client shall promote the best interests of the client by disclosing to the client material facts concerning the transaction of which the licensee has actual knowledge, unless that information is confidential information. Material facts do not include the following when located on or related to real estate that is not the subject of the transaction. 1. Physical conditions that do not have a substantial adverse effect on the value of the real estate. 2. Fact situations. Or 3. Occurrences. Upon satisfaction of a mortgage in Illinois, the lender is obligated to A. Record a release on the borrower's behalf. B. Deliver a release to the borrower within 1 month. C. Pay a $200 release fee to record the loan payoff. D. None of the above. And the answer is B as in boy. Deliver a release to the borrower within 1 month. If any mortgage or trustee in a deed in the nature of a mortgage of real property, knowing the same to be paid, shall not within 1 month after the payment of the debt secured by such mortgage or trust deed comply with the requirements of Section 2 of this Act, provide a release, he shall, for every such offense, be liable for and pay to the party aggrieved the sum of $200. A farmer temporarily installs produce coolers in a leased farm stand in order to prevent spoilage. The coolers would be considered which of the following? A. Trade fixtures that are real property. B. Trade fixtures that are personal property. C. Temporary real property. D. Emblements. And the answer is B as in boy. Trade fixtures that are personal property. Trade fixtures are items of a tenant's personal property that the tenant has temporarily affixed to a landlord's real property in order to conduct business. Trade fixtures may be detached and removed before or upon surrendering of the leased premises. Should the tenant fail to remove a trade fixture, it may become the property of the landlord through a cession. Therefore, the fixture is considered real property. Property can be converted from real to personal property and from personal property to real property by means of which process respectively? A. Assemblage and plottage. B. Application and dissolution. C. Severance and affixing. D. Planting and harvesting. And the answer is C as in Charlie, severance and affixing. Severance is the conversion of real property to personal property by detaching it from the real estate. Affixing or attachment is the act of converting personal property to real property by attaching it to the real estate, such as by assembling a pile of bricks into a barbecue pit or constructing a boat dock from wood planks. The highest form of ownership interest one can acquire in real estate is the A. Legal life estate, B. Conventional life estate, C. Defeasible fee simple estate, D. Absolute fee simple estate. And the answer is D as in dog, absolute fee simple estate. The fee simple freehold estate is the highest form of ownership interest one can acquire in real estate. It includes the complete bundle of rights, and the tenancy is unlimited, with certain expectations. The fee simple absolute estate is a perpetual estate that is not conditioned by stipulated or restricted uses. The distinguishing feature of a defeasible fee simple estate is that A. It can be passed on to heirs. B. It has no restrictions on use. C. The estate may revert to a grantor or heirs if the prescribed use changes. D. It is of unlimited duration. And the answer is C as in Charlie. The estate may revert to a grantor or heirs if the prescribed use changes. The defeasible fee estate is perpetual, provided the usage conforms to state conditions. Essential characteristics are the property must be used for a certain purpose or under certain conditions, and if the use changes or if prohibited conditions are present, the estate reverts to the previous grantor of the estate. Maria acquires a property from her uncle Alfonso. When Maria dies, the estate will pass to Alfonso's other niece, Serena. The type of estate that Maria has in the property is A, conventional life estate, B, legal life estate, C, fee simple defeasible estate, D, tenancy by the entireties. And the answer is A, conventional life estate. A conventional life estate is a freehold estate that is limited to duration to the life of the owner or other named person. Upon the death of the owner or other named individual, the estate passes to the original owner by another named party. A legal life estate is created by law as opposed to a property owner's choice. A property owner has an easement appurtenant on her property. One day, the property is sold to another party who is opposed to the easement. Following the closing, this particular form of easement, A, terminates, B, transfers with the property, C, transfers with the owner to a new property, D, becomes a license on the property. And the answer is B as in boy, transfers with the property. The term appurtenant means attaching to. An easement appurtenant attaches to the estate and transfers with it unless specifically stated otherwise in the transaction documents. A property owner is precluded by deed restriction from developing a 30-foot boat deck. The limitation prompts the owner to sell to another party. The new owner, A, is free to build the dock since the next door neighbor built a similar dock 2 weeks later. B, takes title subject to the same restrictions. C, can build the dock from special permission from the zoning board. D, may build since the restriction is extinguished by the sale. And the answer is B as in boy, takes title subject to the same restrictions. Deed restrictions attached to the title of the property. Therefore, the restriction passes to the new buyer. What is the essential purpose of legal descriptions of real property? A, to create a consistent, unchanging standard for uniquely locating a property. B, to enable courts and attorneys to calculate property size accurately. C, to comply with common law with real property. D, to eliminate cumbersome mets and bounds descriptions. And the answer is A as in apple, to create a consistent, unchanging standard for uniquely locating a property. A legal description of real property is one which accurately locates and identifies the boundaries of the subject parcel to a degree acceptable by courts of law in the state where the property is located. The general criterion for a legal description is that it alone provides sufficient data for a surveyor to locate the parcel. A legal description identifies the property as unique and distinct from all other properties. Which of the following is true of a loan with negative amortization? A, the interest rate on the loan increases as the principal balance decreases. B, payments are not sufficient to retire the loan. C, the loan balance is diminishing or going negative. D, additional interest is being added to the monthly payment? And the answer is B as in boy. Payments are not sufficient to retire the loan. Negative amortization causes the loan balance to increase over the term. This occurs if the borrower's periodic payment is insufficient to cover the interest owed for the period. The lender adds the amount of unpaid interest to the borrower's loan balance. The loan-to-value ratio is used as an underwriting mechanism because A, the LTV determines the profitability of the loan. B, the loan amount needs to be less than the property value. C, borrower tends to inflate the true value of the property. D, a full price loan overfinances the borrower. And the answer is B as in boy. The loan amount needs to be less than the property value. Lenders must have a margin of borrower equity to protect against falling real estate values, which increase the risk of the loan. Without this margin, a lender can incur a loan loss in a foreclosure sale since the proceeds may be less than the loan amount. The method of deriving an investor's return on investment, or ROI, is by A, dividing net operation income by cash flow. B, multiplying the required yield times after-tax cash flow. C, dividing net income by the price paid for the property. D, multiplying cash flow times the price paid for the property. And the answer is C as in Charlie, dividing net income by the price paid for the property. The investment return measure known as return on investment, ROI, is calculated by dividing net income by the value of the investment. This yields a rate of return on investment. Which of the following are examples of closing items not prorated between buyer and seller? A, taxes. B, inspection fees. C, utilities. D, condo assessments. And the answer is B as in boy, inspection fees. Prorated items are expenses that both parties must share. Non-prorated items are one-time individual charges such as sales commissions, recording fees, and title insurance. An investor just purchased a rectangular 2-acre retail lot for $250 a frontage foot. If she paid $100,000 total, what was the depth of the lot? A, 400 feet. B, 250 feet. C, 871 feet. D, 218 feet. And the answer is D as in dog, 218 feet. Since the investor paid $100,000 total, and that equals $250 per frontage foot, there are 400 frontage feet, which is 100,000 divided by 250. If the property is 2 acres, it totals 87,120 square feet. Dividing this by 400 produces a lot depth of 217.8. The Illinois Real Estate Administration Disciplinary Board consists of A, 7 members nominated by the governor and appointed by the General Assembly. B, 9 members, all appointed by the General Assembly. C, 15 members appointed by the governor. D, 7 members appointed by the governor. And the answer is C as in Charlie, 15 members appointed by the governor. The board shall be composed of 15 persons appointed by the governor. Agent Sylvia is developing her website for her internet advertising. To comply with regulations, her site must include A, her name, the sponsoring broker's name, and the brokerage office's city and state. B, her sponsoring broker's name, her office address, and the home office of the brokerage. C, her name, the firm's name, her office address, her web address, and phone number. And D, her name and the firm's name. And the answer is A as in apple. Her name, the sponsoring broker's name, and the brokerage office's city and state. There are no specifics for the homepage, but specifics for advertising real estate services include the following: a licensee advertising, marketing, or soliciting business in connection with license activities must include the following information. 1, the licensee's name, a license with the division, or if applicable, the name registered with the division. If the licensee is part of a team, the team name must be substituted for the individual's licensee name. 2, the sponsoring broker's name. And 3, the city and state where the sponsoring broker's physical office registered with the division is located. Or, in the case of virtual office, a direct link that connects to the sponsoring broker's virtual office, website, or digital platform. When advertising real estate property online, the licensee must include the above plus the city or geographic area and state or country where the property being advertised or marketed is located. If licensee does not hold a real estate license for the jurisdiction where the property is located, the regulatory jurisdictions where the licensee does hold a real estate license. At what point must an Illinois seller's agent disclose his relationship to a buyer in writing? A, no longer than the preparation of an offer or lease. B, prior to showing any properties. C, prior to signing any sale contract. Or D, the agent is not obligated to do this at all. And the answer is A as in apple. No later than the preparation of an offer or lease. A licensee shall disclose in writing to a customer that the licensee is not acting as the agent of the customer at a time intended to prevent disclosure of confidential information from a customer to a licensee, but in no event later than the preparation of any offer to purchase or lease real property. And that covers 25 questions of your real estate exam. If you want more exam help, videos like this, then I would recommend you watch this video right here. Also, you can purchase the state exam prep package, which is linked up below. I'll see you next time. Thanks.